Hello Constitutional Law class, this is Professor David Opterbeck. I'm sending you this video as a sort of greetings and introduction to our new semester. I'm very excited about walking through constitutional law with you this semester, and I wanted to send you a video that contains some background information and some things to get us ready for our semester starting next week. So, first thing that I wanted to give to you is some information about logistics. So I'm going to send you messages periodically through Blackboard. I sent you one already this summer about some reading for the summer. I hope you all got that and are up to speed with it. Just make sure you're checking your email, checking Blackboard, check your spam folder. So if there is something I need to get in touch with the whole class about, I'll send it through Blackboard. I will also post to Blackboard any kind of supplementary documents. So the syllabus is up there now. I will put any PowerPoints that I might use, such as this one. I'll put up on Blackboard, or handouts or other kinds of things like that outside of what's in the casebook and the supplement. So just make sure you're kind of on top of that. I'm going to try to send out weekly summary videos like this video. So this is our first one, kind of introducing next week, either at the very end of next week or the very beginning of the following week. I'll just send brief, 5 to 10 minute video kind of summarizing what we went through for the prior week, what we're looking to for the coming week, and I recommend that you kind of keep on top of those as well. I'll send you notices when they come out, and just take a few minutes to watch them, and hopefully that'll really keep us all on the same page. Our casebook, as you know, is the Sullivan and Feldman casebook. Here is the book itself. You should have the 19th edition of the casebook. In addition to the Sullivan and Feldman casebook, there's a supplement. I understand the supplement is coming out, I think, next week or the week after. So when the supplement comes out, I'll make sure I get a notice around to all of you, and you ought to get the supplement. There are some kind of recent cases and developments that from time to time we'll be going over during the class. There are some other resources that are useful for you but not required. I know many of you are going to be really interested and have been really interested in constitutional law. I know for many of you, and this was true for me 30 years ago, constitutional law is one of those really interesting things that actually makes you want to go to law school. So it's kind of exciting to study. So if you want to keep up on what's going on in the world of constitutional law, one great source that I recommend, if you haven't seen it already, and I'm just pulling it over onto my screen here, is SCOTUS blog. So this is just a blog of currently pending cases that either there are petitions for certiorari or which the court has already accepted. It can be pretty exciting if you've got a case you're really interested in following. There'll be live blogs of arguments and things like that. Really great site, excellent resources. Another one that I recommend, again, not required, but is United States Law Week. The library has a subscription to the Bloomberg BNA resources. You can actually talk to one of the librarians. You can get this delivered into your inbox, and it contains news and information and summaries in the various federal courts, including some lower courts and appellate courts, but also in the Supreme Court. There are other resources, too, that you'll find as you go along, but these are a couple of really good ones. So let me take a few minutes now to talk about the syllabus, and I'm just going to go over here and pull the syllabus up onto my screen. So you should already have the syllabus. One thing immediately that I want you to notice, and that I sent you a message about earlier this summer, is this one little additional assignment. So the bulk of your grade, 95% of your grade, is going to be a traditional law school kind of issue spotter sort of exam during the exam period after the semester. 5% is going to be this little reflection paper on what we call the Charters of Freedom, the Declaration of Independence, the original Constitution, the Bill of Rights, and subsequent amendments. And so check my email that I sent you about that. It doesn't need to be long, it's only about a page, and I'm not really looking for sort of brilliant substance. I'm just looking at it to see that you took some time to read these documents and just reflect on them a little bit. I really wanted you to spend some time reading those documents before we began the semester, because you can go through a whole constitutional law class and never actually read the whole Constitution. And I think it's really useful for you to do that and to just kind of see both some of the familiarity and some of the strangeness, in a way, of the document, some of the formality as well as some of the exalted language in the document, and just get a feel for what kind of legal document it is that we're interpreting when we do constitutional law. So if you look at the syllabus, I've tried to map out each class session. Inevitably, I'm sure we'll make adjustments here and there as we go along, but we'll try our best to kind of keep up with this. You'll see occasionally update memo referenced. Previously, the supplement was in the form of kind of a memo. I'm going to have to update those sections once we get a hold of the supplement, but you'll see that. There really aren't too many kind of twists and turns in the syllabus. One thing I want you to note is I know that on September 8th I'm going to be away at a conference, so I've already marked that as a day that we're not going to meet. I don't anticipate that we'll need a makeup for that date. If there are other dates that come along where I won't be here, I don't anticipate any, but if there are, we'll deal with those as we go along. When you look at the syllabus, you can kind of see the structure of the basic constitutional law class. And I'm going to talk a moment about where we're starting with the judicial function. But you'll see we start with the judicial function. We talk then about the federal powers, and a lot of this has to do with the federal powers in relation to kind of activities that are traditionally thought of as things that are regulated by the states, and we get into the Commerce Clause and some other things there. We then move into further limitations on state powers, and then we start to talk about separation of powers. And as you'll see, when we get into separation of powers, a lot of what we're talking about is kind of the role of the executive in relationship to the role of Congress, and also some material about the judiciary put in there as well. In terms of my background with constitutional law, and I'm going to mention in a moment how all of you will be constitutional lawyers, and that applies to me as well. But very specifically, I've done a lot of scholarship on executive power, and particularly in relation to national emergencies in the cybersecurity space. So if you look at some of my scholarship, you'll see some of the work that I've done in that area. Okay, then as we move through separation of powers, really kind of toward the second half of the semester, then we really start to get into individual liberties. And I think, when you think about constitutional law, for many people, the first thing you think about is individual liberties. Well, what is my right to bear arms? What is my right to marry? What is my right to refuse medical treatment? What are my free speech rights? Those sorts of things. And obviously those are basic, fundamentally important things. We don't start there, though. We really start, for at least half the semester, talking about structural things. And you might feel a little bewildered by that. It might feel a little dry to you. I find it really exciting. In many ways, for me personally, I find it at least as exciting as the individual liberties things, because these questions about the structure of government, about which branch has what power when, are really foundational things in the ordering of any commonwealth, and are really foundational things to the ordering of our commonwealth, and are really foundational things to what you do on a daily basis as a lawyer. So I find all that exciting, but then we do, of course, get into the sexy topics. We start to talk about individual liberties, equal protection, and then toward the end of the semester, we start to talk about civil rights, and kind of depending on time, you'll see I've kind of left some placeholders for now in the syllabus. We'll do some of the, an introduction to some of the free exercise clauses. You'll notice that in a basic constitutional law class like this, we really don't spend a whole lot of time talking about the First Amendment in detail. You get into some more of that if you take an advanced constitutional law class, and we have classes in the First Amendment. So some aspects of this, including some of the free exercise classes, you might dive into more detail in an advanced con law class or in a seminar, but we'll offer some preview in this class. So let me come back to my slides here and just talk for a moment about these documents I asked you to read during the summer that we call the Charters of Freedom. I asked you to look at the Declaration of Independence, and you should realize, of course, that the Declaration of Independence is not a law, it's not a constitution, and it's of course the document that begins the formal process of separation between the colonies and England. We look to it, however, often in kind of an interpretive sense. We look to it often in a what we might call a hortatory sense. That is, we look to it for ideals, we look to it for its exalted language, we look to it in political discourse, and so it's something I wanted to make sure that you read as we move into our course in constitutional law. We have the Constitution of 1789. So we call it the Constitution of 1789 because it's formally ratified in 1789, and that's kind of the original text of the document without any amendments. So what is the kind of overall structure of that text? As you read it, you'll notice, and as we go through parts of it this semester, you'll notice Articles 1 through 3 have to do with the separation of powers within the federal government, the legislature and the executive and the judiciary. Articles 4 through 6 have to do with the relationship between the federal government and the state governments, and also relatedly the procedures for amending the Constitution itself. Article 7 really is, in a sense, a dead article because it was the procedure for ratifying the original Constitution. That is the structure of the original Constitution of 1789, and as you'll see, it's entirely really structural. It's entirely what I sort of refer to as kind of the first part of this semester that we're going to be dealing with. Now, the framers of the Constitution and the states that were going to ratify the Constitution would not have agreed to it without a Bill of Rights. It's just that the Bill of Rights wasn't presented and negotiated and written and ready in time for the ratification of the Constitution itself. So you should just have the background that the 1789 Constitution was adopted and ratified with the expectation that a Bill of Rights would be attached to it. The primary drafter of the Bill of Rights is James Madison. James Madison introduces a series of proposals in 1789 as the Bill of Rights. Out of those series of proposals, the first 10 amendments to the Constitution are one group of those series of proposals that we call the Bill of Rights. And as we go through this class, we'll be looking at, in detail at some of those amendments within the Bill of Rights. I should have mentioned earlier as well, we don't spend a lot of time in this class on criminal procedure. So the Fourth Amendment, search and seizure, the Fifth Amendment, right against self-incrimination, those questions are really left for your class in criminal procedure, but they're also part of the Bill of Rights. So you'll notice that those 10 amendments are really finally amended, or finally ratified by the required number of states by 1791. The 27th Amendment, which is actually the most recent amendment to the Constitution, actually was part of the package that Madison introduced in 1789, but for a whole variety of reasons really wasn't finally ratified by the requisite number of states until 1992. We're not going to spend a lot of time talking about it. It has to do with congressional salaries, and you can read it. There is also one part of the package that Madison introduced that has never been ratified, and that has to do with the apportionment of congressional seats based on a national census. And you might, if you've looked at any of this history before, if you were a history major or something, you'll know there were lots of kind of discussions about apportionment and the census and what role would that play. If you take a course in election law, you'll know that there's a lot of issues today about gerrymandering and apportionment and all that kind of thing, and that's one of the political reasons why that particular amendment was never adopted. And then there are other amendments, and as you see, the 27th is the most recent, so there are 27 amendments in total, including the Bill of Rights. Some of those we'll spend more time talking about than others. Okay, so what about week 1? Here's our kind of preview for the upcoming week. We start off, and there are different ways you can start off a constitutional law class, and our casebook, and my choice, is to start off with the question of judicial power and the famous or infamous case of Marbury v. Madison. Why start with judicial power? Why start with Article 3? I actually want you to ask yourself that as you start to read these materials and as we go through these materials for the week. Of course, one of the preview answers I'll kind of give you is the importance of the role of the judiciary in interpreting this document, right? In interpreting the Constitution. What is the role of the judiciary? As we all know from kind of popular media, political debates, and so on, the question of the judicial role and the interpretive role and the kind of procedures and rules that judges ought to use to interpret the Constitution is really fraught and difficult and subject to lots of interesting debates that we will have some chance to get into in class. So think about that a bit. Why start with judicial power? I do believe it makes sense to start with that in this class. There's a temptation to kind of blow by these cases on standing and mootness and ripeness. And I acknowledge it's not the most fascinating kind of area, the most sexy kind of area of constitutional law. But this is the place, and I mentioned this before, this is the place where everyone, every lawyer, is a constitutional lawyer. So whether you're a transactional lawyer, whether you're a litigator, you're going to be dealing with questions about if there is a claim, who can bring it? Who has a right to be in court? When is a case ready to be in court? When is a case, really done with and shouldn't be back in court? These kind of issues come up all the time. Another area of scholarship that I've done some work on is in standing doctrine in data breach cases. So I do a lot of work in cybersecurity and data breaches, and that's a hot issue right now. In fact, almost all the cases, they're mostly about standing. So although it's not the hot cutting edge thing, in a way it is, and it's something that you are going to deal with probably every day of your life as a lawyer. Okay, so with that little bit of background and introduction, I will see you next week in class.